We are answering the question whether the 2017 presidential election was conducted in accordance with the principles laid down in the Constitution and the written law relating to elections. In paragraphs 12 and 13 of the petition, the petitioners allege that in the conduct of the presidential election, IEBC became a law and institution unto itself, and so flagrantly flouted the Constitution and the written law on elections that in the end, it completely subverted the will of the electorate. In particular, the petitioners urge that the first respondent violated the constitutional principles set out in Articles 81 and 86 by failing to ensure that the conduct of the elections was simple, accurate, transparent, verifiable, secure, and accountable. In support of their case, the petitioners filed several affidavits setting out what, in their view, were egregious irregularities and illegalities, which taken together establish an impregnable case on both limbs of the section, to wit, non-compliance with constitutional principles and the written law on elections, as well as commission of irregularities which affected the results of the elections. We shall address other illegalities and irregularities later, but for now, we shall limit ourselves to the question of transmission of results and transmission of unverified results. The petitioner's major complaint in this matter relates to the transmission of the election results. Olekina, Godfrey Osotsi, and Olga Karani, who were NASA's agents at the National Tallying Center at Bomas of Kenya, deposed that hardly 10 minutes after the polling closed at 5 p.m. on the 8th of August 2017, the presidential elections results started streaming in and were beamed on TV screens at the center without any indication of where they were coming from. On inquiry, IEBC kept fumbling around, alleging that because of network challenges, images of Forms 34A were not coming in as fast as would be expected, and that some might not come in at all. Olekina deposed that by the end of 10th of August 2017, IEBC had supplied them with only 23,000 Forms 34A and 50 Forms 34B. By the time the results were declared on the 11th of August, the results from over 10,000 polling stations had not been received. In these circumstances, he wondered how the final results declared could be relied upon to validate the election. The petitioner's further case is that the results that were streaming in from the 8th of August 2017 to the 11th of August 2017 showed a consistent difference of 11% between the results of Uhuru Kenyatta and Raila Odinga. According to the petitioners, such a pattern indicated that the results were not being streamed in randomly from the different polling stations, but that they were being held somewhere and adjusted using an error adjustment formula to bring in a predetermined outcome of the results. In a nutshell, the petitioner's claim in this regard is that on consideration of the evidence contained in all the affidavits sworn in support of the petition and the submissions made by their counsel, IEBC's conduct of the presidential election was fundamentally flawed and or incompatible with the electoral values and principles of the Constitution, including transparency, accountability, accuracy, security, verifiability, and efficiency. They further argue that contrary to Section 39, 44, and 44A of the Elections Act, IEBC failed to transmit or to promptly and simultaneously electronically transmit presidential election results from the polling stations to the constituency tallying centers and the national tallying center. According to them, this failure was deliberate, systemic, and systematic. The petitioners add that IEBC's Secretary and CEO, Ezra Chiloba, is on record as admitting that as at 17th August 2017, 9 days after the close of the polling, the IEBC was yet to provide all Forms 34A and Forms 34B to the petitioners. And that, bearing in mind that the mischief sought to be cured by the prompt electronic transmission of results and the constitutional obligation of secure, accurate, verifiable, accountable, and efficient elections, the unreasonable delay in the electronic transmission of the results, if at all, as required by Section 39(1)(c) of the Elections Act, grossly affected the integrity and credibility and validity of the results purportedly declared by the IEBC, so the petitioners contended. In response, the first and second respondents submitted that upon completion of counting of votes, the presiding officers would, using the KEMS, take an image of Form 34A, manually enter into the KEMS the result of each candidate, and then simultaneously transmit the image and the results directly to the NTC and to the CTC. The first and second respondents' case, as contained in James Muhati's affidavit, is also that the transmission of results required 3G and 4G mobile network, which was provided by 3 mobile network operators, Safaricom, Airtel, and Telkom Orange. That following a mapping exercise carried out by the first respondent and analysis by the MNOs, the mobile network operators, he does not say when this was done, it was ascertained that about 11,155 polling stations within the country were not effectively covered by either 3G or 4G network. In that regard, it was their case that the presiding officers in such affected polling stations would then be required to move to points with network coverage, or in the alternative, to constituency tallying centers in order to transmit the results. The first and second respondents further urged that even if the electronic transmission of results was not effective as pleaded, the Forms 34A were still physically delivered to the CTC in accordance with the law. They also maintained that the system was not compromised and the results were not in any way manipulated. In conclusion, the respondents urged that the flaws in election transmission of results, if any, cannot be the basis of voiding a presidential election with such a large margin of difference of numbers between the two leading contestants. Counsel for the respondents, the second interested party, as well as the first amicus curiae, the Attorney General, submitted that in an election petition, the paramount consideration is to ensure that the will of the majority of the voters carry the day. In their view, flaws in election results transmission cannot be the basis of avoiding a presidential election with such a large margin in votes as the one in this case. On our part, having considered the opposing positions, we are of the view that the contentions by the first and second respondents ignore two important factors. One, that elections are not only about numbers, as many, surprisingly, even prominent lawyers would like the country to believe. Even in numbers, we used to be taught in school to arrive at a mathematical solution. There is always a computational path one has to take, as proof that the process indeed gives rise to the stated solution. Elections are not events, but processes. As Likot JF opines, quote, elections are not isolated events, but are part of a holistic process of democratic transition and good governance, unquote. Incidentally, IEBC's own election manual, what they call the source book, recognizes that an election is indeed a process. There are many other authorities which speak to this proposition. In Kanyalal, Omar versus Trivedi and others, and the Union of India versus Association for Democratic Reforms and another, the Supreme Court of India, for example, stated that the word election is used in a wide sense to include the entire process of election, which consists of several stages, and it embraces many steps, some of which may have an important bearing of the result of the process. These stages include voter registration, political party and candidate registration, the allocation of state resources and access to media, campaign activities and the vote, the count, tabulation, and the declaration of results. Lady Justice Georgina Wood, the former Chief Justice of Ghana, made the same point and added over stages where she stated, and I quote, the election process is not confined to the casting of votes on an election day and the subsequent declaration of election results thereafter. There are a series of other processes, such as the demarcation of the country into constituencies, registration of qualified voters, the registration of political parties, the organization of the whole polling system to manage and conduct the elections, ending up with the declaration of the results and so on, unquote. According to the European Human Rights Committee, the process also includes the right to challenge the election results in a court of law or other tribunal. Here in Kenya, the issue of elections as a process was discussed in the case of Karanja Kabage versus Joseph Kiuna Kariambegu Nganga and two others, where the High Court had the following to say, and I quote, an election is an elaborate process that begins with the registration of voters, nomination of candidates to the actual electoral offices, voting or counting and tallying of those votes, and finally, the declaration of the winner by gazettement. In determining the question of the validity of the election of a candidate, the court is bound to examine the entire process up to the declaration of results. The concept of free and fair elections is expressed not only on the voting day, but throughout the election process. Any non-compliance with the law regulating these processes would affect the validity of the election of the Member of Parliament, unquote. This case was cited with approval by this court in the matter of the gender representation in the National Assembly and the Senate. Therefore, the process of getting a voter to freely cast a vote, and more importantly, to have that vote count on an equal basis with those of other voters, is as important as the result of the election itself. It is also a fact of common notoriety that there were serious protests following the declaration of the 2007 presidential election results. The violence arising from those protests not only claimed over 1,000 lives and led to the destruction of and the looting of property worth hundreds of millions of shillings, but also drove the entire country to the precipice of destruction. It is also common knowledge that following that violence, the government formed the Independent Review Commission, commonly known as the Kriegler Commission, to inquire into the conduct of the 2007 elections and the cause of that violence. One of the critical areas of that commission's focus was the integrity of the vote counting, the tallying, and the announcement of presidential election results. Here we will let the Kriegler report speak for itself in the following words. I quote, "The accessibility of an election depends very considerably on the extent to which the public feel that the officially announced election results accurately reflect the votes cast for candidates and the parties. It depends, too, on factors such as the character of the electoral campaign and the quality of the voter register, but reliable counting and tallying in a sine qua non if an election is to be considered legitimate by its key assessors, the voters, the system of tallying, recording, transcribing, transmitting, and accounting and announcing results was so conceptually defective and executed, counting, tallying during the 27th to 30th December 2007, and even hereafter, and the announcement of the individual results were so confused and so confusing that many Kenyans lost whatever confidence they might have had in the results as announced. While integrity is necessary at all stages in the electoral process, nowhere is it more important than in counting and tallying, unquote. Among the significant recommendations the Kriegler Commission made related to the use of technology in the electoral process, it recommended as follows, quote, "Without delay, the Electoral Commission of Kenya, ECK, starts developing an integrated and secure tallying and data transmission system which would allow computerized data entry and tallying at the constituencies, secure simultaneous transmission of individual polling station level data to the National Tallying Center, and the integration of this results handling system in a progressive election results announcement system," unquote. Pursuant to these recommendations, the process of integrating technology into the conduct of elections was undertaken, starting with the use of biometric voter registration, equipment to register votes on a pilot basis in the run-up to the 2010 referendum. In the 2013 election technology, in the 2013 elections, technology was applied for registration of votes, voter registration, and for result transmission. However, that did not work very well in the 2013 general election, and it was one of the key issues that was raised in the 2013 presidential petition before this court. Consequently, in 2016, the Joint Parliamentary Select Committee on Matters relating to the Bipartisan Independent Electoral and Boundaries Commission was formed, discussed the use of technology in elections, and made far-reaching recommendations which led to, among others, extensive amendments to the Elections Act to provide for use of technology and also technology-dedicated regulations, the Elections Technology Regulations 2017. These changes, in our view, were meant to realign several pieces of election-related legislation with the principles of the Constitution and the electoral jurisprudence that had been developed by the courts. The cumulative effect of the changes was the establishment of what is now referred to as the Kenya Integrated Election Management System, the KIEMS. Henceforth, technology would be deployed to the process of voter registration, voter identification, and the transmission of results to the constituency and to the National Tallying Center. Towards this end, Parliament enacted Section 44 of the Elections Act, subsection 1 of which provides as follows: there is established an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. Subsection 3 thereof provides as follows: the Commission shall ensure that the technology in use under subsection 1 is simple, accurate, verifiable, secure, accountable, and transparent. Section 39(1)(c) of the Elections Act then squarely addresses the results transmission aspect of these changes in the law, and it provides as follows: for purposes of a presidential election, the Commission shall, A, electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. B, tally and verify the results received at the national tallying center. And C, publish the polling result forms on an online public portal maintained by the Commission. Regarding the voter register, this court in the 2013 Raila Odinga decision had observed that there was no single voter register, but an aggregation of several parts into one register. To cure this anomaly, Parliament amended Section 4 of the Election Act to provide, as I read, there shall be a register to be known as the Register of Voters, which shall comprise A, a polling register in respect of every polling station, B, a ward register in respect of every ward, C, a constituency register in respect of every constituency, D, a county register in respect of every county, and E, a register of voters residing in Kenya. Section 10(1) of the Elections Act provides that a person whose name and biometric data are entered into a register of voters in a particular polling station and who produces an identification document shall be eligible to vote in that polling station. Parliament also introduced a new section 6A to provide inter alia that the Commission shall, not later than 60 days before the date of a general election, open the register for verification of biometric data by the members of the public at their respective polling stations for a period of 30 days. And 2, the Commission shall, upon expiry of the period for verification specified under subsection 1 above, revise the register of voters to take into account any changes in the particulars arising out of the verification process. 3, the Commission shall, upon expiry of the period for verification specified under subsection above, publish the register of voters online and in such manner as may be prescribed by the regulations. All these legislative enactments have one objective: to ensure that in conformity with the Constitution, elections are free, they are fair, they are transparent, and they are credible. It is important to note the terms simple, accurate, verifiable, secure, accountable, and transparent, and grafted into these provisions are the same constitutional principles in Articles 10, 38, 81, and 86 of our Constitution. We must, in that context, now proceed to determine whether the first respondent conducted the presidential election in accordance with the principles laid down in the Constitution and the law. The mystery of Forms 34A and the conundrum of election transmission. By far the most critical and persistently claimed non-compliance with the law was that the first respondent announced results on the basis of Forms 34B before receiving all Forms 34A. It was also alleged that the results announced in Forms 34B were different from those displayed on the respondent's public web portal. This was contrary to Section 39(1)(c) of the Elections Act. The petitioners also argued that the non-compliance was in violation of Articles 81E and 86 of our Constitution. The non-compliance also went contrary to the Court of Appeal's decision in Minor Kiai. The petitioners also claimed that many results were transmitted from the polling stations unaccompanied by the scanned image of Form 34A, contrary to the provisions of Section 39(1)(c) of the Elections Act as read together with Sections 44 and 44A of the Act. In response, the first respondent submitted that the difference in the results announced on the forms and the public web portal did not offend any law or regulation in view of the fact that the results in the forms were final, while the results on the public web portal were only statistics. Mr. Nyamodi, counsel for the first respondent, also submitted that in view of the Court of Appeal's decision in Minor Kiai, the system of transmission had to be reconfigured to allow for manual transmission. Counsel explained that the source document that the first respondent relied on to do so was no longer Form 34A, but Form 34B. Likewise, counsel submitted a similar fate had befallen Form 34C in terms of format and structure. Towards this end, counsel informed the court that the original Form 34C, which had contained a Form 34A tally, was reconfigured by the first respondent to exclude that tally so as to conform to the decision in the appellate court case in Maina Kiai. As for the controversy surrounding the electronic transmission of results, Council submitted that such transmission was a mere conveyance belt and nothing more. To this, Mr. Ngatia, Counsel for the third respondent would later add that the electronic transmission with which the petitioner was obsessed was like a matatu and no more. What was important, Counsel urged, was what was conveyed, meaning the results, as opposed to the manner in which it was conveyed, meaning the electronic transmission. The first respondent also submitted that the security features of the Kenya Integrated Electoral Management System was programmed to capture and transmit only one image. In some instances, text data was transmitted instead of the filled and scanned forms 34A. At any rate, argued the first respondent, the omission of untransmitted forms was cured by the uploading of the said forms onto the public portal. According to the IEBC, the transmission of the wrong images did not affect or invalidate the result contained in the statutory forms 34A. Later, it was urged access to the scanned forms was granted to the public through the website. Still on transmission of results, the petitioners highlighted various discrepancies. For instance, that there was transmission of results from slightly more than 11,000 polling stations, other than gazetted polling stations, contrary to Regulation 7. It was also alleged that the streaming of results commenced a few minutes after 5 p.m., being the official closing time for all polling stations. In addition, the petitioners questioned the streaming of results in constant percentages of 54% and 44% in favor of the third respondent and the first petitioner, respectively. The petitioners further claimed that there were numerous discrepancies between the results declared in Forms 34A and those in Forms 34B from various polling stations across the country, contrary to Section 39 of the Elections Act, as read with Regulation 82, thus compromising the integrity of the election. In response, the first and the second respondents countered the accuracy in some of the allegations by providing contrary figures through a number of deponents. However, the said deponents also admitted that indeed there were discrepancies in the results in Forms 34A and Forms 34B, spread across the country, but attributed them to human errors, fatigue, and the fatigue of the election officials. They further contended that the discrepancies in question did not in any event affect the result of the election. The first and the second respondents added in further response that the 11,155 polling stations from which the impugned results were streamed were in areas which were not served by the 3G and the 4G network coverage. The The petitioner's case and the responses thereto by the respondents have conjured in our minds a puzzle of labyrinthine proportions regarding Forms 34A. In the face of a very clear and unambiguous Section 39(1)(c) of the Elections Act, what went wrong with this critical document? The case for the petitioners is that the second respondent, in exercise of his responsibility as the returning officer of the presidential election, declared the results for the election of president before receiving all the Forms 34A from the 40,883 polling stations from across the country. Incomplete results, argued Mr. Otiende Amolo for the petitioners, could not be a basis for a valid declaration. The respondent's answer to that assertion is that the results were declared on the basis of Forms 34B, all of which had been received by the time of the declaration, by the time the declaration was made. In an affidavit sworn by Koitameto Lekina in support of the petition, there is telling correspondence which we had referred to earlier, but which we reproduce in the present context. On the 10th of August 2017, the deponent, acting on behalf of the petitioners, wrote to the second respondent in the following words, and I quote, "Your brief on the above subject at Bomas on the 10th August 2017 at around 9 p.m. refers. You informed Kenyans that and the world at large that IEBC had received over 40,000 Forms 34A and about 170 Forms 34B. We have requested IEBC for all these forms for purposes of verification. Members of your secretariat have informed us that they cannot avail 29,000 Forms 34A as at 11 p.m. of 10th August 2017. We kindly request the Commission expedite release of the remaining Forms 34A and B to enable us complete the verification exercise," unquote. Again, on the 14th of August 2017, the deponent wrote, quote, "This is a follow-up on our letter dated the 10th of August 2017. Until now, IBC has only furnished NASA with 29,000 Forms 34A and 108 Forms 34B. We urgently require the unsupplied 10,000 Forms 34A and 187 Forms 34B to complete the list of documents the Commission was supposed to release to all the candidates in the just concluded general elections. Attached, please find a list of the outstanding 187 constituencies for your immediate action," unquote. On the 14th of August 2017, the Secretary and CEO of the first respondent wrote as follows. "Reference is made to your letter dated the 14th August 2017 requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the required Forms 34B immediately. We are, however, not able to supply Forms 34A as at the moment, but the same shall be availed to you as soon as possible. It is a fact that the correspondence quoted above did take place, and the contents of the said correspondence were never controverted. On this basis, a number of questions therefore arise. A, why was the first respondent not able to immediately supply the petitioner's agents with all the Forms 34B upon declaration of results if, as it was submitted, the said results were based on the same, and all of which were said to have been availed? B, why was the first respondent not able to supply all the forms 34A said to be around 11,000 to the petitioners at 14th August 2017, 4 days after the declaration of the results? C, were all the scanned copies of Forms 34A electronically transmitted to the National Tallying Center simultaneously with those transmitted to the Constituency Tallying Center in accordance with Section 39(1)(c) of the Elections Act? If so, why would it have been impossible for the first respondent to avail those copies to the petitioners? If not, why were they not transmitted in the manner required by the law? We sought answers to these questions as we listened to the submissions of counsel on the emerging conundrum. The submissions of Mr. Nyamodi on behalf of the first respondent made disturbing, if not startling, revelations. According to counsel, the first respondent used Forms 34B as opposed to Forms 34A to declare the final results of the presidential election. He emphasized that at the time the final results of the presidential election were declared, all Forms 34B had been collated. It was counsel's submission that the declaration of sections 39(2) and 3 of the Elections Act 2011 by the Court of Appeal as being inconsistent with the Constitution curtailed the first respondent's ability to change, amend, or alter the results transmitted from the constituency. According to him, therefore, the decision of the Court of Appeal in the minor Kiai case extinguished the concept of provisional results. Consequently, the numbers manually entered into the KEMS did at the close of polling and transmitted simultaneous to the CTC and the NTC bore no status in law. They were mere statistics, although, as Mr. Muhati stated in his affidavit, the presiding officer had to show the agents present the entries made for confirmation before transmission. Mr. Nyamodi further explained that the completion of the transmission of the images of Forms 34A was dependent on the availability of 3G and 4G network coverage. In respect of areas lacking 3G and 4G network coverage, the respondents established alternative mechanisms to ensure completion in transmission of the image of the Form 34A. The procedure adopted in the transmission and tallying of results of the presidential election was in conformity with the decision of the Court of Appeal in the minor Kiai case. On the basis of this process, counsel submitted that the petitioner's allegation that the first respondent deliberately predetermined and set itself on a path of subverting the law by being a law unto itself was unfounded. In addition, counsel submitted that the determination by the Court of Appeal on the finality of presidential election results declared by the constituency returning officer also changed the structure of Form 34C. Regulation 37, Subregulation 3B, for avoidance of doubt, provides, as I now read, Upon receipt of Form 34A from the constituency returning officers under Sub-Regulation 1, the chairperson of the commission shall tally and complete Form 34C. However, the first respondent had to allegedly modify Form 34C to reflect the entry of Forms 34B, which was the form declared by the Court of Appeal to be the source document to determine the winner of a presidential election instead of Forms 34A. Mr. Nyamodi concluded by reaffirming that the way the first respondent structured its transmission system was largely based on the Court of Appeal's decision in the minor KI case, which did not interfere with or negate the will of the people resident in Form 34A. What was Mr. Nyamodi saying? We were left to ask. Was counsel admitting that the second respondent indeed, as claimed by the petitioners, had declared the presidential results without having received all Forms 34A? Was he in the same vein also admitting that not all Forms 34A had been electronically transmitted to the National Tallying Center from the polling centers as required by law? Where did the language of statistics as opposed to results emerge from? Was counsel disclosing the fact that fundamental changes had been made to the KIMS system at the sole discretion of the first respondent without reference to all the players in the presidential election contest? Be that as it may, Mr. Nyamodi persistently argued that the conduct by the first and second respondents, to wit, of declaring results solely based on Forms 34B without reference to Forms 34A, of not scanning all Forms 34A and simultaneously transmitting them to the NTC, of configuring Form 34C to exclude Form 34A tally and only include the Forms 34B tally, of introducing the language of statistics as opposed to results, that all these actions were necessitated, nay, required by the decision of the Court of Appeal in the minor KI decision. We were, on our part, at pains to understand how the Court of Appeal decision in that case could have provided a judicial justification for the conduct of the first and second respondents. The Attorney General, appearing as amicus curiae, having been so admitted, and despite having been clearly restrained from submitting on the so-called impact of the minor KI decision, also appeared to suggest in his closing remarks that somehow the appellate court's decision in that case had changed the landscape of the conduct of elections in this country. In the above context, we reiterate that the main questions that this court has to grapple with at this stage are as follows. A, whether the second respondent declared the results of the presidential election before he had received all the results tabulated on Forms 34A from all the polling stations. B, whether all the Forms 34A had been electronically transmitted from the polling stations to the National Tallying Center. We've read the extensively reasoned and powerfully rendered decision by the Court of Appeal in the minor KI case. We find nowhere in that decision where the learned judges of appeal suggested, or even appeared to suggest, that by affirming the High Court's decision, which had declared Section 39, subsection 2 and subsection 3 of the Elections Act unconstitutional, the Court of Appeal somehow, for unstated reasons, lent judicial imprimatur to the first and second respondent to either circumvent or simply ignore the provisions of Section 39(1)(c) of the Elections Act. On the contrary, the appellate court's decision was an unstinging reaffirmation, if not a restatement, of the letter and spirit of the constitutional principles embodied in Articles 81, 86, and 138(3)(c) relating to the conduct of elections, and we have shown why that is so. Section 39(1)(c) of the Elections Act, for avoidance of doubt, provides as follows, quote, "For purposes of a presidential election, the Commission shall, A, electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. B, tally and verify the results received at the National Tallying Center, and C, publish the polling result forms on an online public portal maintained by the Commission." Clearly, with this provision in mind, the Court of Appeal in minor KI decision was categorical as it rendered itself, as I quote, "We are satisfied that with this elaborate system, the electronic transmission of the already tabulated results from the polling stations contained in the prescribed forms is a critical way of safeguarding the accuracy of the outcome of elections, and do not see how the appellant or any of its officers, read the first respondent, can vary or even purport to verify those results," unquote. And the Court of Appeal continued this way. "The appellant, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president electronically transmitted to it from the near 40,000 polling stations, is required to tally and verify the results." The appellate court had earlier made a pronouncement with which we are in total agreement to this effect. Quote, "It is clear that the polling station is the true locus for the free exercise of the voters' will. The counting of the votes as elaborately set out in the Act and the regulations, with its open, transparent, and participatory character, using the ballot as the primary material, means, as it must, that the count there is clothed with a finality, not to be exposed to any risk of variation or subversion," unquote. Given this very clear elucidation of the law regarding the imperative for electronic transmission of results from the polling station to the NTC, how could the Court of Appeal's decision in minor KI have provided a justification for declaring the results of the election of the president without reference to Forms 34A? How was it a basis for the reconfiguration of Form 34C? so as to render Forms 34A irrelevant in the final computation of the results. But most critically, how did the Court of Appeal's decision relieve the first respondent from its statutory responsibility of electronically transmitting in the prescribed form the tabulated results of an election for the president from a polling station to the CTC and to the NTC in accordance with Section 39C of the Elections Act? At the end of the day, neither the first nor the second respondent has offered any plausible response to the question as to whether all Forms 34A had been electronically transmitted to the NTC as required by Section 39(1)(c) of the Elections Act. What remained uncontroverted, however, was the admission by Ezra Chiloba that as of 14th August 2017, 3 days after the declaration of the results, the first respondent was not in a position to supply the petitioner with all Forms 34A. Counsel for the first and second respondents, by insisting that the presidential results were declared on the basis of Forms 34B, all of which were availed, also implicitly admitted that not all Forms 34A were availed by the time the second respondent declared the final results for the election of the president. In addition to the above, the relevant to this aspect of the petition, pursuant to an application by the petitioners, the court issued an order requiring the first respondent to supply the petitioners and the third respondent with all the scanned and transmitted Forms 34A and 34B from all the 40,883 polling stations on a read-only basis with the option to copy in soft version. Had the court's order been complied with, it would have unraveled the mysterious puzzle surrounding Forms 34A. Regrettably, according to the information made available to the court by its appointed experts, the first respondent only allowed a read-only access to this information without the option to copy in soft version only 2 hours to the closure of the court proceedings, which never fully happened anyway. By this time, however, the puzzle had already been unraveled in the mind of the court, and we shall shortly explain why. In any event, it is claimed in the petition, and IEBC in its response conceded, that 2 days to the election date, IEBC announced that it was going to be unable to electronically transmit results from 11,000 polling centers because they were off the range of 3G and 4G network. Consequently, its officers would have to move to spots where they could get network to be able to transmit. Come the election date on the 8th of August 2017, IEBC claimed it was unable to transmit results from those stations. According to submissions by counsel for IEBC, such inhibition set in place the use of a complementary system of transmission of results envisaged under Section 44A of the Elections Act, which is in essence the physical delivery of Forms 34A to the CTC, and hence the delay in the declaration of the results from those polling stations. With tremendous respect, we cannot accept IEBC's said explanation. Failure to access or catch 3G and or 4G network, in our humble view, is not a failure of technology. Surely, IEBC's ICT officials must have known that there are some areas where network is weak or totally lacking and should have made provision for alternative transmission. It cannot have dawned on IEBC's ICT officials 2 days to the elections that it could not access network in some areas. In stating so, we note that under Regulations 21, 22, and 23 of the Elections Technology Regulations 2017, IEBC was required to engage a consortium of telecommunication network service providers and publish the network coverage at least 45 days prior to the elections. In that regard, we take judicial notice of the fact that in one of its press briefings preceding the elections, IEBC assured the country that it had carefully considered every conceivable eventuality regarding the issue of the electronic transmission of the presidential election results and categorically stated that technology was not going to fail them. IEBC indeed affirmed that it had engaged 3 internet service providers to deal with any network challenges. We cannot therefore accept IEBC's explanation of alleged failure of technology in the transmission of the presidential election results. The so-called failure of the transmission was, in our view, a clear violation of the law. In any case, in his affidavit, Mr. Muhati, IEBC's ICT director, stated, averred that in polling stations of the range of 3G and 4G network coverage, the presiding officers were instructed to move to points with network coverage or to the constituency tallying centers in order to electronically transmit the results. It is important to note that once the POs who were off the network range scanned the results into Forms 34A and typed the text messages of the same into the KIMS and pressed the submit key, a process IEBC told the country was irreversible. All that remained was for the POs to move to vantage points where 3G or 4G network would be picked, and the details could automatically be transmitted in seconds. As is also clear from the information posted in the IEBC's website, among the 11,000 polling stations IEBC claimed were off the 3G and 4G range are in Bomet, Bungoma, Busia, Homa Bay, Kajiado, Kericho, Kiambu, Kisumu, Kisii, Kirinyaga, Nyeri, Siaya, and Vihiga counties. It is common knowledge that most parts of those counties, have fairly good road network infrastructure. Even if we were to accept that all of them are off 3G and 4G network range, it would take at most a few hours for the POs to travel to vantage points from where they would electronically transmit the results. That they failed to do that is, in our view, an inexcusable contravention of Section 39(1)(c) of the Elections Act. We further note that at the time of declaration of results, IEBC publicly admitted that it had not received results from 11,883 polling stations and 17 constituency tallying centers, that in its letter of the 15th August 2017, IEBC also admitted that it had not received authentic Forms 34A from 5,015 polling stations representing 3.5 million voters. Dr. Aukot, the first interested party in the above context, echoed the petitioner's case that the whole process of counting, tallying and transmission of results from polling stations to the CTC and finally to the NTC lacked fairness and transparency. That IEBC itself admitted that it had network problems which hindered its prompt transmission of results, but by the time of announcement of results, transmission had been completed. What was IEBC's answer to the above contention? In his submissions before us, Mr. Nyamodi, learned counsel for IEBC, outlined to the court the mode of the transmission process of the results and submitted that after the manual filling in of Form 34A, the POs then keyed in the results into the KEMS kit, took the image of the Form 34A, and then simultaneously transmitted the same to the constituency and national tallying centers. Our understanding of this process is that the figures keyed into the KEMS corresponded with those on the scanned images of Forms 34A. In these circumstances, we do not understand why those figures, which learned counsel referred to as mere statistics, that did not go into the determination of the outcome of the results, differed. In these circumstances, bearing in mind that IEBC had the custody of the record of elections, the burden of proof shifted to it to prove that it had complied with the law in the conduct of the presidential election, especially on transmission of the presidential election results, and it failed to discharge that burden. Of further note is that IEBC strenuously opposed the petitioner's application for access to its servers, claiming that such access would compromise the security of the data in those servers. After considering the application, we overruled that objection and partly allowed the same. Though we did not therefore accept IEBC's said claim of compromising the security of its servers, considering the fact that having spent billions of taxpayers' money, IEBC should have set a robust backup system. Nevertheless, to assuage those fears, we granted the petitioners a read-only access, which including copying where the petitioners so wished. The report from the court-appointed IT experts, Professors Joseph Sevilla and Elijah Omwenga, holders of PhDs on IT and lecturers in Strathmore and Kabianga universities, respectively, shows clear reluctance on the part of the IEBC to fully comply with this court's order of the 28th August 2017 to provide the information requested. In summary, the following are the items that were not availed to the petitioners and to the third respondent and the court. A, firewalls without disclosure of the software version. IEBC refused to provide information on internal firewall configuration, contending that doing so would compromise and affect the vulnerability of their system. The court-appointed ICT experts disagreed with that contention and said it was difficult to ascertain whether or not there were any hacking activities. B, IEBC was also required to provide certified copies of the certificates of penetration tests conducted on the IEBC election technology system prior to and during the 2017 election pursuant to Regulation 10 of the Elections Technology Regulations. I'll take that again. IEBC was also required to provide certified copies of the certificate of penetration tests conducted on the IEBC election technology system prior to and during the 27 election pursuant to Regulation 10 of the Elections Technology Regulations 2017. These were not provided. Instead, IEBC issued and certified documents and certificates by professionals which did not conform to the regulation. C, IEBC was also required to provide specific GPS location of each KM's kit used during the presidential election for the period between the 5th August 2017 and the 11th August 2017. This was not provided. IEBC instead provided the GPS locations for the polling stations, which was not ordered to be granted. D, documents for allocated and non-allocated KM's kits procured was provided. However, the information on whether the kits were deployed or not was incomprehensive. E, the court ordered access to technical partnership agreements for IEBC election technology system, including a list of technical partners, kind of access they had, and list of APIs for exchange of data with partners. The documents were issued with the exception of the list of APIs. The court-appointed ICT experts said full information on APIs would have enabled determination of what kind of activities may have taken place. The court had also ordered IEBC to provide the petitioners with the login trail of users and equipment into the IEBC servers, the login trails of users and equipment into the KM's database management systems, and the administrative access login into the IEBC public portal between the 5th of August 2017 to date, being the date of the court order, which was the 28th August 2017. These were also not provided. Instead, IEBC provided pre-downloaded logs in a hard disk whose source it refused to disclose. The IT experts agreed with the petitioner's contention that the first respondent should have demonstrated that the logs emanated from the IEBC servers by allowing all parties to have a read-only access. Alternatively, the first respondent could have accessed the information in the presence of the petitioner's agents. Partial live access was also only purportedly provided on the 29th August 2017 at about 3:50 p.m. without ability to access the logs or even view them. The exercise was therefore a complete violation of the court order, and the access was not useful to the parties or to the court. It is clear from the above that IEBC in particular failed to allow access to two critical areas of their servers: its logs, which would have proved or disproved the petitioner's claim of hacking into the system and altering the presidential election results, and its servers with forms 34A and 34B electronically transmitted from polling stations and CTCs. It should never be lost sight of the fact that these are the forms that Section 39(1)(c) of the Elections Act specifically required to be scanned and electronically transmitted to the CTCs and the NTC. In other words, our order of scrutiny was a golden opportunity for the IEBC to place before the court evidence to debunk the petitioner's said claims. If IEBC had nothing to hide, even before the order was made, it would itself readily have provided access to its ICT logs and servers to disprove the petitioner's claims. But what did IBC do with it? It contemptuously disobeyed the court order in these very critical areas. So where does this leave us? It is trite law that failure to comply with a lawful demand, leave alone a specific court order, leaves the court with no option but to draw an adverse inference against the party refusing to comply. In this case, IBC's contumacious disobedience of this court's order of 28 August 2017 in critical areas leaves us with no option but to accept the petitioner's claims that the IBC's IT system was infiltrated and compromised, and the data therein interfered with, or IBC's officials themselves interfered with the data or simply refused to accept that it had bungled the whole transmission system and were unable to verify the data. The petitioners also made claims that some forms 34A supplied to them did not relate to any of the existing gazetted polling stations or tallying centers. That while 15,558,038 people voted for the presidential candidates, 15,098,646 voted for gubernatorial candidates, and 15 million. Sorry. The petitioners also made claims that some forms 34A supplied to them did not relate to any of the existing gazetted polling stations, tallying centers, that while 15,558,038 people voted for the presidential candidates, 15,098,646 voted for gubernatorial candidates, and 15,008,818 voted for members of parliament, raising the questions as to the validity of the extra votes in the presidential election. No satisfactory answer was given to the latter issue, and we must also hold the first respondent responsible for that unexplained yet important issue. Having therefore shown that the transmission of results was done in a manner inconsistent with the expectations of Section 39(1)(c) of the Elections Act, we must of necessity return to the principles in Articles 81 and 86 of the Constitution, which we have already reproduced. Of importance are the expectations of transparency, accountability, simplicity, security, accuracy, efficiency, and especially verifiability of the electoral process. These terms should be understood to refer to A, an accurate and competent conduct of elections where ballots are properly counted and tabulated to yield correct totals and mathematically precise results. B, an election with a proper and verifiable record made on the prescribed forms executed by the authorized election officials and published in the appropriate media. C, a secure election whose electoral processes and materials used in it are protected from manipulation interference, loss, and damage. D, an accountable election whose polling station, constituency, and national tallies, together with the ballot papers used in it, are capable of being audited. And E, a transparent election whose polling, counting, and tallying processes, as well as the announcement of results, are open to observation by, and copies of election documents easily accessible to the polling agents, election observers, stakeholders, and the public, and as required by law, a prompt publication of the polling results forms is made on the public portal. Verifiability must have had strong significance in the 8th August election because the presiding officers were required to verify the polling station's results in the presence of polling agents before sending them to the CTC and NTC in using the KIEMS kit. The minor KI decision made it clear that Form 34A, being the primary document, becomes the basis for all subsequent verifications. We have already addressed the import of the refusal to obey a court order, and we further note that the whole exercise of limited access to the first respondents' IT system was meant to confirm and verify both the efficiency of the technology and also verify the authenticity of the transmissions allegedly made to the CTC and to the NTC. Non-compliance and failure, refusal or denial by the IEBC to do as ordered must be held against it. So, what of Article 138(3)(c) of the Constitution? It provides, in a presidential election, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the results, unquote. The critical element here is the duty placed upon the Commission to verify the results before declaring them, to ensure that the results declared are the ones recorded at the polling station, not to vary, not to change or alter the results. The duty to verify in Article 138 is squarely placed on the Independent Electoral and Boundaries Commission, the first respondent herein. This duty runs all the way from the polling station to the constituency level and finally to the National Tallying Center. There is no disjuncture in the performance of the duty to verify. It is exercised by the various agents or officers of the first respondent, that is to say, the presiding officer at the polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. The verification process at all these levels is elaborately provided for in the Elections Act and the regulations thereunder. The simultaneous electronic transmission of results from the polling station to the constituency and the National Tallying Center is not only intended to facilitate this verification process, but also acts as an insurance against potential electoral fraud by eliminating human intervention or intermeddling in the results tallying chain. This, the system does by ensuring that there is no variance between the declared results and the transmitted ones. In the presidential election of the 8th August 2017, however, the picture that emerges is that things did not follow this elaborate but clear constitutional and legislative roadmap. It has been established that at the time the second respondent declared the final results for the election of the president on the 11th August 2017, not all results as tabulated in Forms 34A had been electronically and simultaneously transmitted from the polling stations to the national tallying centers. The second respondent cannot, therefore, be said to have verified the results before declaring them. The said verification could only have been possible if, before declaring the results, the second respondent had checked the aggregated tallies in Forms 34B against the scanned Forms 34A as transmitted in accordance with the provisions of Section 39(1)(c) of the Elections Act. Given the fact that all Forms 34B were generated from the aggregates of Forms 34A, there can be no logical explanation as to why, in tallying the Forms 34B into Form 34C, this primary document, Form 34A, was completely disregarded. Even if one were to argue, which at any rate is not the case here, that the verification was done against the original Forms 34A from all the polling stations, which had been manually ferried to the tallying center, this would still beg the question as to whether the scanned forms were and why, as to where the scanned forms were and why the manually transmitted ones arrived faster than the electronic ones. The failure by the first respondent to verify the results in consultation with the second respondent before the latter declared them, therefore, went against the expectations of Article 138(3)(c) of the Constitution, just as the failure to electronically and simultaneously transmit the results from all the polling stations to the National Tallying Center violated the provisions of Section 39(1)(c) of the Elections Act. These violations of the Constitution and the law call into serious doubt as to whether the said election can be said to have been a free expression of the will of the people as contemplated by Article 38 of our Constitution. It was further urged in court by a number of counsel for the first and second respondent that by disregarding Forms 34A and exclusively relying on Forms 34B, men of whose authenticity would later be called into question, in the tallying process, the said respondents were simply complying with the Court of Appeals decision in Maina Kiai. We have already heard that we find little or nothing in this section, in this decision, that is in the Maina Kiai decision, to suggest that by deciding the way it did, the appellate court restrained or barred the first respondent from verifying the results before declaring them, or that it was relieving the former from the statutory duty of electronically transmitting the results. What the second respondent was barred from doing by the Court of Appeal and by the High Court was to vary, alter, or change the results relayed to the National Tallying Center from the polling stations and constituency tallying centers under the guise of verifying. But be that as it may, how spectacularly reassuring to the Kenyan people would it have been if the second respondent on that night of August 11th, 2017, had commenced the declaration of the results with these words: Fellow Kenyans, the results I am about to declare are exclusively based on Forms 34B, which I have received from all the 290 constituency tallying centers countrywide. I have not verified these results against those tabulated on Forms 34A from all the 40,883 polling stations countrywide. This may sound strange, but I am simply doing this in compliance with the Court of Appeal's decision in the minor KI case. This decision by the appellate court requires me to treat the results as tabulated by the various returning officers as final, and not to attempt to verify them against the electronically transmitted Forms 34A. You will therefore have to bear with me, as court orders must at all times be obeyed. However, all hope is not lost, since I have availed all the Forms 34A on our public portal. Any candidate, election observer, or member of the public is free to download these forms and compare the results thereon against the ones I am just about to declare. If such an exercise should reveal serious discrepancies, then one can petition the Supreme Court to scrutinize them and even annul them, since the Supreme Court has original and exclusive jurisdiction over such disputes. He failed to do the above, and apart from the duty to verify, the first respondent also has the responsibility to ensure that the system of voting, counting, tallying results is verifiable. This is in conformity with the Article 86 of the Constitution, which requires that, quote, at every election, the Independent Electoral and Boundaries Commission shall ensure that A, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. B, the votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. C, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. And D, appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including safekeeping of elections materials, unquote. This provision places upon the first respondent the onerous responsibility of devising and deploying election systems that the voter can understand. The first respondent must further be expected to provide access to crucial information that can enable either a candidate or a voter to cross-check the results declared by it with a view to determining the integrity and the accuracy thereof. In other words, the numbers must just add up. We note in the above regard that even where Parliament found it necessary to make provisions for a complementary system, it would not escape from the dictates of Article 86 of the Constitution, and hence Section 44A of the Elections Act provides, as I read, notwithstanding the provisions of Section 39 and Section 44, the Commission shall put in place a complementary mechanism for the identification of voters and transmission of election results that is simple, accurate, verifiable, secure, accountable, transparent, to ensure that the Commission complies with the provisions of Article 38 of the Constitution, unquote. When called upon to explain why all the Forms 34A had not been scanned, transmitted and published on the online portal in line with Article 34 of the Elections Act, the first respondent through counsel alluded to some form of complementary mechanism. However, the description of such a mechanism did not appear to us to meet the yardsticks of verifiability inbuilt in the Constitution and Section 44A of the Elections Act. In their submissions, counsel for the respondents and the second interested party urged us not to annul the election on the basis of minor inadvertent errors. We entirely agree. We have already categorically acknowledged the fact that no election is perfect. Even the law recognizes this reality, but we find it difficult to categorize this violation of the law as minor inadvertent errors. IEBC behaved as though the provisions of sections 39, 44, and 44A of the Elections Act did not exist. IEBC behaved as though the provisions of Article 88(5) of the Constitution requiring it to, quote, exercise its powers and perform its functions in accordance with the Constitution and national legislation, quote, unquote, did not exist. IEBC failed to observe the mandatory provisions of Article 86 of the Constitution, requiring it to conduct the elections in a simple, accurate, verifiable, secure, accountable, transparent manner. Where is transparency or verifiability when IEBC, contrary to Articles 35 and 47 of our Constitution, was still in the contumacious disobedience of this court's order, refuses to open its servers and logs for inspection? Having therefore carefully considered all the affidavit evidence and submissions of counsel for all the parties, we find and hold that the petitioners herein have discharged the legal burden of proving that the second respondent declared the final results for the election of the president before the first respondent had received all the results from Forms 34A from all the 40,883 polling stations, contrary to the Constitution and to the applicable law. We also find and hold that the second respondent declared the said results solely on the basis of Forms 34B, some of which were of dubious authenticity. We further find that the first respondent, in disregard of the provisions of Section 39(1)(c) of the Elections Act, either failed or neglected to electronically transmit in the prescribed form the tabulated results of an election of the president from many polling stations to the National Tallying Center. At this juncture, we must restate that no evidence has been placed before us to suggest that the process of voter registration, voter identification, manual voting, and vote counting were not conducted in accordance with the law. As a matter of fact, nobody disputes the fact that on 8th of August 2017, Kenyans turned out in large numbers, endured long hours on queues, and peacefully cast their votes. However, the system thereafter went opaquely awry, and whether or not the third respondent received a large number of votes becomes irrelevant, because read together, Sections 39(1)(c) and 83 of the Elections Act say otherwise. In passing only, we must also state that whereas the role of observers and their interim reports were heavily relied upon by the respondents as evidence that the electoral process was free and fair, the evidence before us points to the fact that hardly any of the observers interrogated the process beyond counting and tallying at the polling stations. The interim reports cannot therefore be used to authenticate the transmission and eventual declaration of results. For the above reasons, we find that the 2017 presidential election was not conducted in accordance with the principles laid down in the Constitution and the written law on elections, in that it was inter alia either transparent, neither transparent nor verifiable. On that ground alone, and on the basis of the interpretation we have given to Section 83 of the Elections Act, we have no choice but to nullify it.